I welcome representatives from the Civil Aviation Safety Authority. Mr Carmody, I'll let you fill your water glass and then I'll ask you if you've got an opening statement.
I have, Chair. Thank you. Thank you very much.
Take your time.
Thank you. Shane Carmody, Chief Executive Officer of the Civil Aviation Safety Authority. Thank you, Chair. Thank you for the opportunity to make a short opening statement. I'd like to update the committee on three topical areas of the Civil Aviation Safety Authority before we move on to questions. I wanted to begin by reiterating that CASA in its current form was established with a focus being first and foremost on aviation safety. This stemmed from the tragic Monarch and Seaview accidents in 1993 and 1994, respectively, when the then Civil Aviation Authority, the regulator, our predecessor, was found to have failed in its safety responsibility by placing commercial considerations ahead of the safety of passengers. I don't want this to occur again. One of the three topics I'll mention today is the significant progress CASA has made on the finalisation of the Civil Aviation Safety Regulations. The journey began in around 1995 with 55 regulations to be made. By 2010 there were 17 left. By 2016 there were 10 left. Last year we completed 7, so we have 3 regulations left before calling an end to the regulatory development program. Put another way, we're 95% complete, but with a lot of work done last year. On remotely piloted aircraft systems, it's another topic I'd like to mention. One of the recommendations of the References Committee last year related to establishing a registration system and a competence test for RPAS or drones. We released a policy proposal on the 25th of January this year for consultation on registration of drones, including an online education course, and the consultation closes today. As of this morning, we've received over 4,100 responses, which is the most we've had in relation to one consultation ever, as far as I can recall. As per our practice, once this consultation closes, we evaluate the responses to determine if any amendments need to be made to our proposal. We will then publish a summary of consultation and the comments approved for publication and make the necessary changes to our regulations. At this stage, we're aiming to introduce RPA registration for RPA operator certificate holders from the 1st of July, registration and accreditation for the excluded category from the 1st of September, and registration for RPA or recreational RPA operators from the 1st of November this year. We're also continuing to work on the other areas outlined in the report. The third item I'd like to mention today is the recent changes to community service flights. To be clear, these changes are about community service flights, that is, flights conducted by volunteer pilots, free of charge, and coordinated by a third party. They're not about emergency services, not about aerial ambulance or aeromedical flights. These changes are not trying to close down the valued service the CSF organisations offer the rural and regional communities. On the contrary, we are trying to fulfil our mandate by making certain these flights are as safe as possible, noting that it is unreasonable to assume members of the public who accept charitable medical flights would have a meaningful awareness of the resulting increased potential for exposure to risks that may be associated with these flights, the pilot's experience level, or the airworthiness status of the aircraft. It is our view that community service flights, particularly those arranged, coordinated or brokered by Angel Flight, have an accident incident rate significantly higher than private operations. Given this, I've acted in the interest of aviation safety to raise the minimum standards for pilots operating these flights. One final point, since consultation closed on the community service flights discussion paper and instrument, and I signed the instrument that imposes conditions on licences for pilots wishing to conduct community service flights, I've had a number of additional representations regarding the restriction of rotary wing aircraft in community service flight activities. After considering the feedback, I acknowledge that the consequences might be to limit the field of potential CSF volunteers. Limiting potential community service flight volunteers was not my intention. Given this, I have an instrument being prepared to amend the current instrument and include rotary wing operations, which I will lodge in accordance with appropriate parliamentary process. Thank you, Mr Chairman. I'm happy to take questions from the committee.
Thank you very much.
Senator, I'm happy for Senator
Patrick?
Patrick to go.
Thank you.
I've got a few questions, but you can kick off.
Okay, I might just ask a few questions. I'm not sure if you listened, Mr. Carmody, to the testimony in, I think it was Brisbane. I was last week into rural and regional airfares.
No, Senator, I didn't.
Okay.
I did see a transcript of some of which I skimmed through, but I wasn't even aware at the time, Senator.
Okay, so there were a couple of issues that were raised that, and no, I'm not directing this at you in any way, shape or form, but really after a response of some sort. One of them was in relation to a High Court case that has just passed, Work Health Authority versus Outback Ballooning Limited. So you're aware
Familiar
of
with
the
that, Senator? That High Court handed down its decision a couple of weeks ago.
Yeah. Now, it's been, and I know I won't be critical of the High Court. They define the law as it is. I note that Justice Edelman made a very, very forceful dissenting judgment, but the rest of the justices basically have ruled that personnel operating an aircraft need to comply not just with CASA regulations but with local work health and safety regulations. Mr. Alec, I presume that's a reasonable summation.
Senator, Dr. Alec is probably
sorry.
much more of an expert on it than I am,
Yep.
Senator, but it was a co-jurisdictional arrangement, I suppose, in my mind.
Sure.
That's the best way to describe it.
Okay. There's been an immediate expression by industry that creates a significant problem for them because now, particularly in relation to someone who's flying from Queensland and then to South Australia and then on to Western Australia, they're now burdened with 3 different regulatory requirements imposed upon them by the states. I'm wondering whether CASA's view, noting we don't really want to impose regulations unnecessarily on pilots and aircraft operators, whether CASA will will review that decision and make some recommendations in respect of that decision, noting that anything, I guess, that's passed in the federal parliament by way of Section 109 of the Constitution could override that High Court decision.
Sure. Thank you. Jonathan Alec, Executive Manager, Legal and Regulatory Affairs. Senator, your summary was accurate. I think there's a risk, not so much in what you've had to say, but in the perception that it overstates matters to some extent. The High Court decision, the majority decision, basically held that there is room for both aviation legislation and work health and safety regulation in that space, so long as there's no direct inconsistency between the two. And what the case decided was that there was no what they call field exclusion or indirect inconsistency issue. So the mere fact that the civil aviation legislation governs activities in the aviation operational environment would preclude the ability for any state work health and safety legislation or other legislation for that matter to be involved. Prior to 2011 and to some extent after that was the situation. And I'm not aware of any huge controversies that arose about the coextensive jurisdiction of work health and safety authorities and civil aviation. We're certainly mindful of that judgment, and we were watching those proceedings very carefully and very closely, if for no other reason than because, certainly in our experience, there are areas in which CASA is not really properly equipped or designed to be regulating. I mean, I won't go into hypothetical examples, but the initial case in 2011 involved an injury or death, I believe, that occurred within the cockpit of an aircraft, an operational environment without any question. The Outback case involved something quite different, where it was a passenger embarking on a commercial balloon flight, an area where CASA could and in fact did have regulatory responsibilities and had imposed them most appropriately on that operator. There are a whole host of other areas, however, where those lines can become increasingly blurry. A pilot, it's somewhat fanciful, I suppose, but a pilot who slips on a banana peel in the dispatch room, operational environment, is that something CASA should be regulating? We were talking about, in some of these flights when you have to get off the plane and go in a little bus from the aircraft back to the terminal, we speculated, well, what if a passenger overcome with fumes in that transport vehicle? Would that be a CASA regulatory issue? Would there be something else? So we feel that in the absence of really most extraordinary circumstances where there would almost certainly be a direct inconsistency anyway, that there is room for co-jurisdiction here. We have done and we will continue to work with work health and safety authorities. In fact, we've already arranged to meet with their national organization in April to talk about the implications of this decision, to try and ensure that we don't undercut or override one another's jurisdiction.
Okay, can I invite you to have a look at on notice, to have a look at the Alliance Airlines testimony, because they stated a concern, and I would appreciate their concern they provided an example of a passenger boarding an aircraft, whether or not that was the start or the end of a navigation which is exclusively a Commonwealth jurisdiction, whether or not there's some way of, with the Commonwealth law, to draw the line so it extended to common laws for pilots and aircraft operators as they go from state to state. There would be benefit in that, in making sure that you don't have a pilot who has to now get their mind across all sorts of legislation depending on the state in which they're flying into or out of.
Right. Well, first of all, I have actually seen that testimony.
You have?
I'm aware of those issues,
Yeah.
and I'm alive to the concerns
Sure.
they have. They're not fanciful. By the same token, those are realities with which operators have been dealing for years.
Yeah, but we can make it easy for them.
Oh, look, that's part of the reason we're going to meet with the
yeah.
work health and safety authorities. We don't want to create situations that
and
complicate
I would hope
matters.
industry as well. You might consult with industry about their concerns in relation to it.
Well, we
Is it-
consult with all of those with whom we're meant to consult with. This is an initial meeting with work health and safety because these are the two jurisdictions that now will be looking at each
Sure.
other more closely. But your points are well taken.
You're aware of the new bill that's entered into the Parliament in relation to changing the Act.
I'm aware of the
which
bill,
governs it.
Senator, yes.
And consistent with the theme that amendment is intended to invoke. Once again, we're trying to reduce the regulatory burden on the industry.
Right.